This is Yasin Kadi. Yasin Kadi is a Saudi Arabian millionaire. And this is Ahmed Yusuf. Ahmed Yusuf works with the Al Barakaat Foundation. The Al Barakaat Foundation helps Somali migrant workers send money back to Somalia. In October 2001, these men discovered that their funds in the European community have been frozen. Without any warning and without knowing where to go, they were feeling pretty lost. Let's give them a bit of context. We begin with the United Nations. In particular, the UN Security Council. Chapter 7 of the Charter tasks the Security Council with identifying threats to international security. And it also tasks them with deciding what measures to use against these identified threats. Member states are obligated to carry out Security Council decisions directly and through international agencies that they are party to. Using these powers, the Security Council passed Resolution 1267. Resolution 1267 and its successors required member states to, inter alia, freeze the funds and financial resources of individuals identified as associates of Al-Qaeda, the Taliban, and Osama bin Laden. 1267 also creates a committee responsible for seeing implementation of Resolution 1267 and its successors. But more importantly, the committee was tasked with creating and maintaining a list of individuals and entities who were to be sanctioned under 1267 and its successors, kind of like Santa Claus, but more vague. There was no review mechanism for the listing or delisting of entities. Member states of the UN could ask to add or remove individuals from the list, but the Sanctions Committee was the sole decider on that matter. Listed individuals were not forewarned and were not told what evidence there was against them. They could not defend themselves directly in front of the committee. The committee eventually adopted guidelines for the listing procedure and even introduced a focal point review mechanism which let individuals address the committee directly. We now look at European implementation of Resolution 1267. The Council has said time and again that measures provided for by the resolution fall under the scope of the treaty, and community legislation was necessary to avoid distortion of competition. The Council adopted acts and updates to reflect progress of the Security Council decisions. This leads us to the decisions of the Court of First Instance. Both applications before the Court of First Instance alleged 3 grounds for the annulment of the concerned regulations. Mr. Kadi alleged a breach of his right to be heard, breach of right to respect for property and the principle of proportionality, and a breach of the right to effective judicial review. For its part, the Al Barakaat Foundation alleged that the Council was incompetent to adopt the contested regulation, alleged an infringement of Article 249(c), and claimed a breach of its fundamental rights. The Court of First Instance rejected Al Barakaat's claims that the Council was not competent to pass the contested regulation, They offered a lot of reasons for why, but none perhaps as important as that found in paragraph 67 of the ECJ judgment. The Court of First Instance cited Articles 60 and 301 as being very special in that they expressly contemplate situations in which action by the community may prove to be necessary in order to achieve not one of the objects of the community as fixed by the EC Treaty, but rather one of the objectives specifically assigned to the European Union by Article 2 EU, namely the implementation of a common foreign and security policy. Concerning fundamental rights, the Court of First Instance claimed it lacked jurisdiction to review community sanctions that implemented Resolution 1267 and its successors. The Court of First Instance reasons that while the community itself is not a member of the UN, it is bound by Security Council resolutions to the extent, and in that community member states are bound by Security Council decisions. The Court of First Instance felt that reviewing the lawlessness of the contested regulation would also be reviewing the lawlessness of the Security Council resolution, and as such, it refrained from exercising any judgment on that matter, rejecting the applicant's claims. The Court of First Instance applied the just cogence test, but they never made clear why they chose to do this, or what the rubric was for passing or failing. All that was established was that they did not think the contested regulation failed this test that they made up. Both cases appealed to the ECJ. In the next few slides, we'll see the opinions of Advocate General Maduro. In 2008, the Advocate General advised the ECJ to set aside the CFI decisions and annul the contested regulation. The Advocate General claimed the community courts did have jurisdiction to review the contested regulation. The AG wrote that the indefinite freezing of assets was a serious breach of the right of property. To be subject to severe sanctions without the right to an independent tribunal was a breach of the right to be heard and the right to effective judicial review. The AG offered that if there were appropriate judicial control at the UN level, community intervention might not have been necessary. The AG felt that the contested regulation did not fit in the community legal order based on the rule of law. And the ECJ felt the same way. The ECJ clarified that their review concerned the contested regulation and not the Security Council resolution. The ECJ set aside the CFI judgments and annulled the contested regulation. It felt the contested regulation did not respect the rule of law or due process. It also said that improvements brought under the 1267 procedure by amendments to the 1267 resolution were insufficient to protect fundamental rights within the community. Here's what happened next. Subsequent European acts on the matter have attempted to address the ECJ's fundamental rights concerns, and the 1267 Committee now includes an ombudsperson in the review mechanism. The case sparked a great deal of academic debate. Please find the cited articles at the end of the slideshow. Some academics were quick to label the ECJ decision as dualist and warned of what this might mean for international legal order. Some accepted the court's dualist approach and said that it was necessary in order to maintain fundamental rights in the Union. Others felt that the monist dualist debate was useless, irrelevant, and out of date. The main point to take away from the Kadi case is that all measures enacted in the Union, even if stemming from obligations outside of the Union legal order, must comply with Union core values of fundamental rights and the rule of law.